Okay, well, we'll get going. Good afternoon. My name is Lynneth Stuart-Hill from the University of Victoria, and I'm sure you weren't quite expecting me to be up here, and you're looking going, where is Stu Peterson from the University of Alberta, who was supposed to be chairing our session. Stu was unable to join us at the conference, so I am filling in on his spot. Stu neglected to tell me when he asked me to fill in for him the challenge that I would have with our guest speakers, with two of them not owning cell phones. So you can imagine trying to communicate with them. Bruno has one, the other two don't, very proudly. So it's been a real adventure trying to make sure, as Eric's plane was coming in and everything else, that we could all get here. Today we're going to be talking to you about physical employment standards and the current issues and challenges that we face. This is a relatively new area, and it's certainly one that we're trying to gain some momentum in within the CSEP organization. Just to give you a little bit of background, that when we take a look at our physical employment standards and developing pre-employment physical abilities tests, a lot of this work has been done by physiologists off the side of their desks. And as we started to realize that there were a few people universally doing this type of work, we started to say, well, we need to really try to start to come together to get some ideas of some of the ways that we can actually standardize some of the protocols and things that we're using. And Dr. Nigel Taylor, who is here today and will be presenting for you this afternoon, organized a first Australian conference on the physiological and physical employment standards. And it was so well received that they thought, well, that we should try and do this again. And actually, last summer in 2015, Stu Peterson and some of his cohorts, Greg Anderson and Randy Dreger, put together a second international conference on physical employment standards that was very, very successful in Canmore, Alberta. There was a special issue that came out of the conference that is actually a free access or open access issue. So if you are interested in this area and you haven't seen the issue, I'd strongly recommend that you take a look at the review papers that were published in there. Coming up in 2018, there will be a third international conference as we try to move this area of physiology forward. This is going to be happening in Portsmouth, UK, July 17th to 19th. And again, we have the contact information for the individual who will be doing that conference if any of you are interested in attending. And certainly if this is an area of research and interest for you, I strongly recommend that you come to these conferences. They're very, very interesting. So I'm just going to do a little bit of an intro before we get to our main speakers, just to really try and set the stage a little bit, because we are a very different branch of sciences. We are so applied compared to some of the research that we have been privy to enjoying this week as we've gone through the conference. And certainly when we take a look at the groups that we are working with, often we think about working with emergency responders such as police and paramedics and fire departments. But certainly we see that increasingly there's a lot of other occupations that are getting into this idea of having pre-employment physical abilities tests. So certainly within the logging industry, within mill workers, miners, conservation officers, wardens, the Coast Guard. So when we look at this, what we're trying to figure out is how do we determine if somebody is fit for their duty or even fit to do their work safely and effectively. And as you will certainly hear from our panel, this is becoming an increasing concern for a lot of employers as well as unions and the employees themselves. As you will also see today, or you probably saw from our guest panel, that this is definitely a multidisciplinary field of study, which makes it so interesting and very exciting to be in. Certainly we have to deal not only with the physiology of the job performance, but we have to consider human rights and ethics. We also have to take a look at actually how we design these tests and our measurement standards that we have as well, and that we really don't have some of the same luxuries we have as when we are developing fitness tests for athletic populations. Okay. So just to give you an idea, and I sort of reviewed this already a little bit, but there are a lot of different organizations that use physical employment standards and take a look at doing job and physical demands types of analysis. So again, realizing that this is an expanding field that certainly is, from the industrial sector anyway, is garnering a lot of interest and attention. So, how did we get here? And this is one of the things that I want people to be aware of, is that, of course, a lot of us start out our careers as exercise physiologists, and we're often interested in health and or sport performance. And when we take a look, particularly at our high-level athletes, the ones that are performing their sport for their job, per se, we know a lot about them, and they usually tend to be a very homogeneous group for whatever their sport or activity is. So if we look at an NHL team or an NFL team or a women's national volleyball team, they're usually all around the same age, usually the same sex. They're trained for their sport very, very specifically, and they're usually incredibly motivated to be able to perform very, very well. With these athletes, when they're going to perform their job or their event, we know where it's going to be, we know when it's going to be, what time of day, we know how long they might have between events, and what can we do to optimize their rest and recovery. We know how many players will be on the team. Are they an individual event? Are they a team event? We usually know something about their opposition. We've done our homework. We know who they're going to be facing. And usually we can take into account some of their environmental conditions as well to try and make sure that we can, again, optimize their performance. With all of this, what it does is it leads us to our fitness and performance tests that we have for these athletes that are going to reflect their physical abilities to do their job and perform very well when they get to their different events. Okay. Now, I like to term the groups that we work with our occupational athletes, and when we start to take a look at trying to design tests for this group, there's a lot of considerations we have to take into account in terms of both doing the research, taking a look at what are the physical demands of the different tasks that they do, and then what are the tests that we can develop that will reflect the demands of their job, and how on earth do we set the standards that they need to attain for safe and effective performance. Now, if we start to look at this and we compare it back to our athletes, we don't know always the time of day that they're going to get called out to perform their work or their job. They might be asleep when they get called out if they're volunteer firefighters or they're volunteer search and rescue. It might be in the morning, it might be in the afternoon. They might have had a previous call out that they're still having to recover from, and it might have been an hour ago, it might have been 4 hours ago. We don't have no idea, unlike sports, what the intensity and duration is going to be of the job that they're going to have to perform, and even how the intensity of duration of the previous calls that they might have had. You know, we certainly know that some calls can be very short if we're looking at emergency response, but one of my co-op students right now is looking at the search and rescue group, and some of those individuals can be out for over 14 hours on the West Coast. And I certainly would not want to be a volunteer for this weekend, although apparently we get to go out with them tomorrow. Yeah. We also don't know when these groups necessarily last had something to eat or were hydrated. They might even be in the middle of eating if we look at police or fire or people that are working in duty shifts. The other thing, we don't know if they're on long calls. Do they have the ability to eat and hydrate during their call? And all those types of challenges can have an impact on their ability to perform their job safely and effectively. Our other challenges that we have is certainly the people that we deal with. Within any occupational group, we can be dealing with both sexes, of course, performing the job, and there can be different challenges around sex and gender. We can be dealing with different age groups from sort of late teens right up into the mid to late 60s, and perhaps even older when we do look at some volunteer groups as well. The environment can also be very challenging and very, very unpredictable for us. Again, as we take a look, we could be dealing with extremes in heat and cold, altitude and sea level, and sometimes even below the ocean as well if we are dealing with our clearance divers. So there's going to be huge challenges all around environment, people, even the equipment or the personal protective equipment that they need to carry with them, or their load carriage, can have a drastic impact on the physical demands of the job, and will have an impact on the types of tests we select and the standards or the cut scores that we would be wanting to set. The other part is, of course, is that they also sometimes have very unique tasks as well that we have to somehow assess the physical demands of, and then try to determine how can we best test their physical ability to do some of these very unique tasks. And again, I don't think you'll see too many people having to wrestle wolves or lift grizzly carcasses. The other challenge that we have is when we take a look at our test development is this idea of simulations versus reality. And we do have this gap between what we can study and the reality of the workplace. So, and even in our test development, the length and durations of the tests that we can realistically do with these individuals versus the actual time that they might be performing tasks out in their workplace. So one of the big things we have to do, of course, is to try and take our research out to their work locations, and that can be a real challenge in itself as well. And even when we take a look at our testing locations as well, trying to get a valid test environment for these individuals that does somehow simulate their work environment. So certainly when we go out, we can be out following them either on their snow machines or their ATVs or in helicopters or planes. Sometimes we have to go right into their burn buildings and things with them, or dress up to hide from the turkey poachers as we assess their physical abilities while they're doing their different types of tasks. And this can make it a huge challenge to start to develop valid and reliable tests that will reflect what they do while they're out here. So what we're going to be doing this afternoon is taking a look at a number of different areas around the challenges of developing pre-employment standards and cut scores. And our three speakers today are going to be really working or discussing three areas. There's, of course, numerous things that we have to consider. I've tried to very briefly highlight a number of them. But certainly when we take a look at PES, there's the main ones that we're going to look at today is Eric Adams is going to talk to us about law and human rights and some of the considerations we have to take into account there. Something very unique that we often don't have to consider in some of our other areas of physiology. We are also going to be taking a look at some of the research methods and how do we set cut scores and test standards, and the reliability and the validity of tests that we choose. And with all of that, starting to take a look at how do we choose these tests, and once we have chosen the tests that are reflective of the physical demands of the job, how do we set cut scores that will give us an idea that we are choosing people that are safe and effective for doing the job that they have been hired to do. So without further ado, I'm going to get to the stars of the event. We're going to be starting with Eric Adams from the University of Alberta, who will be talking with you about legal and human rights issues. Thanks, Eric.
So my goal today is to talk, or really connect, I suppose, the world of physical standards of employment with human rights law and employment law and labor law more generally, especially in the Canadian context. Although the issues that I'm going to raise have relevance across the Western world, Australia, the UK, and the United States as well. The scientific community that's involved in the creation of this testing, as well as the firms and organizations that employ such testing, ignore the human rights angle of this issue at their peril, since physical standards of employment in the workplace have been and will continue to be legally challenged across a number of jurisdictions. So I want to begin this afternoon by explaining how employment is regulated in Canada, like in other common law countries, before turning to understand how physical standards for employment, or PSE, raise a host of legal issues. British Columbia is actually an especially relevant place to raise this issue, since the Supreme Court of Canada decision in a case called Mayorin arose in BC and established the general legal framework for discussing and analyzing PSE in the human rights context. So I'll end my talk then with discussing some best practices from a human rights law perspective of designing and implementing PSE. So just looking how to advance. Did I do it? Yes, there it is. So let me just set, first of all, a little bit of the legal background. And when you have forgotten everything else that I'm about to say in the next 20 minutes, I want you to remember this one, because this is a party trick. You can use this when you're meeting people out and about in the real world. What is the difference between employment law and labor law? Most people conflate them or use them interchangeably. In the law, actually have two separate meanings. So here's the difference. This is the part you're going to remember. Employment law is about regulating the individual contract of employment, or the non-unionized workplace. Labor law is about regulating unionized workplaces. So at the University of Alberta, I belong to a unionized workplace environment. I'm governed by labor law. If you work at McDonald's and there's no union, then you have an individual contract with the employer, and you are regulated by employment law. Now, both labor law and employment law in Canada are regulated overwhelmingly at the provincial level. Our Constitution says that employment and labor law are to be regulated by provinces. And so every province in Canada has both specific employment law, specific labor law, and human rights law that governs the workplace relationship between employees and the employer. There is also federal labor law, specifically for those employees that fall within federally regulated industries. That's only about 6% of the Canadian workforce. So 94% of Canadians are regulated at the provincial level of employment, but a handful of workers fall under the Canada Labour Code and the Canadian Human Rights Act. Most of these legal regulations are similar with minor differences of wording, but think about, for example, again, to turn to the example of McDonald's. If McDonald's has workplaces across Canada, it has to abide by the minimum wages that are different in different provinces, those minimum wages established by the individual provincial employment standards legislation of each distinct jurisdiction. Where did this employment law come from? Well, Canada inherited it from the UK, and it was originally called master and servant law. And everything you really need to know about master and servant law is captured by the title master and servant law. Basically, the idea that there is a master in this relationship, that's the employer, and they get to dictate the terms of employment really at their will, and that the state's role is to enforce that those terms of employment of the master by either imprisonment or fines, or originally by bodily punishment. So there you have a 8-year-old doing dangerous work in industrial England, very much the servant. Over the course of the 20th century, master and servant law transformed into what is now known as employment standards legislation. Similarly, where unions were once illegal and repressed by the state over the course of the 20th century, they came to be legally regulated, first by being granted legal status, and then folded into a highly regulated system where labor relations are heavily regulated by labor law, again, in each province and then federally. And this new regime then is premised on an entirely different conception, namely that the state is not there to enforce the terms of an employer, but rather to protect employees who the law says are more vulnerable in the employee relationship. Work, the Supreme Court of Canada has said, is fundamental to personal identity and to notions of self-worth. And so both as a matter of common law and of statute law, the Canadian employment law and labor law is really turned on its head and been premised on the idea that employees are actually needful of protection in a variety of ways. And typically then these are expressed in the employment law context by setting, say, minimum hours of work, minimum wages, providing mandatory maternity leave, say, for individuals who have children. And in labor law by regulating how strikes and lockouts occur, when they can occur, when unions become certified or decertified. Well, alongside this general change in orientation has remained two fundamental concepts that we also need to understand. The first is what's called the freedom of contract, and the second, management rights. Freedom of contract, then, which originally said you've got to be able to set whatever terms you want in your employment relationship. And we've already seen that that's been limited by employment standards legislation, which says, well, you can't set every term of your employment relationship. For example, you can't agree to work for 10 cents an hour because that's going to infringe the minimum wage requirements of employment standards legislation. Freedom of contract, though, still, courts have said, is a fundamental term of Canadian employment law. And that means that employers and employees should be able to set the terms of their bargain. And how does that impact physical standards for employment? Well, physical standards for employment are one of those terms. For example, if you need to be able to pass a test in order to get a job, that's a requirement that employers are exercising their freedom of contract in establishing. If you need to pass a test to keep a job, then again, that's an expression of the freedom of contract. In the labor law context, we'd call that the right of management rights, the employer to set and structure the workplace, to set the rules and conditions of functioning safely and efficiently in the workplace. And again, physical standards of employment would be an expression of the employer's management rights. So courts try and respect, then, the ability of employers to set the terms of their own bargain within the limits set by employment standards legislation. Well, that freedom of contract, again in the 20th century, translated into the right to hire who you wanted, but also to fire who you wanted. And Canadian employment law still has as a fundamental premise, you can fire people for virtually any reason at all, with a little asterisk beside that. I'll come back to that in a minute. If you don't like someone, you can terminate them. If they wore a t-shirt that you don't like the color of, you can fire them. Is that a dumb reason to fire someone? Yes, it is. Is that protected as an expression of your freedom of contract? Yes, it is. So what translated through the 20th century then was the exercise of that freedom of contract to hire who you wanted and to fire who you wanted into an employer's right to discriminate. Don't want to hire someone because you don't like women in the workplace? You can exercise that right under your freedom of contract. Don't like Jews or blacks? Again, you can terminate them under the freedom of contract. And for most of the 20th century, Canadian employment law said, that's perfectly fine. You're just exercising your freedom of contract. The law really has nothing to say about that. Increasingly, though, that became untenable as human rights consciousness developed, and there began to be social movements against that kind of expression of power. And so the emergence then of human rights codes, which began after the Second World War and really took shape in the 1960s and 70s. So I've given you Section 13 of the British Columbia Human Rights Code. It looks very similar, Section 13 does, to most other provincial human rights codes, as well as the Canadian Human Rights Act. Well, let's look just closely then at what Section 13 says. Again, it says that freedom of contract to hire who you want and to fire who you want is not entirely free at all. It's actually constrained by human rights considerations. So you can no longer decide not to hire someone because you don't like women or Jews or blacks, and you can't terminate someone on that basis. In fact, you can't terminate anyone for any of the reasons in the protected grounds of discrimination. Originally began as a fairly narrow band of prohibited grounds that began with ideas of race and ethnic origin, but over the last 30 years has expanded to include sex, and most recently a number of jurisdictions adding gender expression, you see there, and gender identity, including just this fall, the Canadian Human Rights Act. Well, again, what does that mean for physical standards of employment? It means that if physical standards from employment discriminate against individuals on the basis of their sex or age or physical disability, and someone's hiring decisions are made on the basis of that physical standard for employment, the Human Rights Act says that's discrimination and that is prohibited. Except that there is an exception, and it's in subsection 4, which says that bona fide occupational requirements will not be deemed to be discriminatory. So, again, firing someone because you don't like the fact that someone is Jewish, you're never going to have a bona fide occupational requirement that says that it matters whether you're Jewish or Christian or Muslim or any other religion. Well, what about a test, though, that requires pilots to have a certain level of vision in order to fly a plane safely? That discriminates against individuals, perhaps on the basis of age, certainly on the basis of physical disability. If someone has a visual impairment, court is going to say every time, yes, that's discrimination because you're not hiring someone with poor eyesight, but every time they're going to say that is a bona fide occupational requirement because there is a connection between the ability to see and fly planes safely. And so even though that discriminates on a prima facie basis, a lawyer would say it's a bona fide occupational requirement and therefore is fully lawful. This regime is replicated not only across all the provinces, but internationally too, where in the US, the UK, and Australia, you have very similar mechanisms for protecting employment on human rights standards. Why Australia needs 4 pieces of legislation to do what every other jurisdiction needs 1, you can ask Nigel. I'm sure he'll have a good explanation. But essentially, the framework is almost identical. The concept that you cannot discriminate on the basis of protected grounds, but that bona fide occupational requirements, sometimes go by different names, but essentially that concept will be saved as non-discriminatory. Well, in Canada, as I mentioned at the outset, the case that really brought this into the legal framework was the decision in Mayorin. And there's Tawny Mayorin. In Ms. Mayorin's case, she was a member of the initial attack team. I always thought that was a better job name than law professor. The initial attack team went in to fight these dangerous forest fires in the BC hinterland, and she was an employee of the government of British Columbia. And she challenged her termination from that position on the basis that the physical standards for employment that the employer insisted upon was discriminatory. That case went to the Supreme Court of Canada, as we'll see in a minute. And thinking about her case always, for me, calls to mind another image, which is this one. When I started doing work in this area, I sent away to the BC government for the 1991 coroner's report that led to the standard testing which Mayorin challenged. And in that report is this image, and it's of a burnt timber field on the Sunshine Coast where Ernest Kingston died in a forest fire in 1991. Ernest Kingston had just returned to his logging job, had a bad back, was overweight, he had no training to deal with fighting forest fires, and when the wind changed and a fire swept into the area, he was overcome with flames and tragically perished there. The coroner's report from his death led directly to the standards that were imposed on Tawny Mayorin. And I think about this image because, of course, safety matters in these workplaces and lives are on the line. And for me, that's a human rights issue too. The ability to function safely in a workplace, to go home to your family at the end of the day, I think is very much a human rights issue as a workplace that doesn't discriminate. But this image also brings to mind one of the problems in the Mayorin decision, which was that from this event, the BC government imposed a series of fitness testing totally unconnected to the specifics of the workplace, and just transporting requirements from one job site to another with a general idea that people should be fit to work in forests is never going to be able to pass the legal framework that's established by the Maorian decision. So let's turn to that now. So what happens in Maorian? Well, she begins as a contract firefighter in the late 80s. She works that job for a number of years. She was satisfactory in her job. And in 1994, again, implementing the recommendations of that coroner's report, the BC government imposes a series of fitness tests on Ms. Maorian and her coworkers. One of them is a 2.5-kilometer run, which she needs to complete in under 11 minutes. She fails to do so on 3 occasions. The last occasion, she fails by 49.4 seconds. And I always say to my students, you know, when the Supreme Court of Canada quotes 49.4, that Ms. Maorian has got a good chance of winning her case when they're down to the decimal place on her failure rate. She was terminated on the basis of that failed test, and she grieved that termination under her collective agreement, arguing that that test was an infringement of BC's human rights legislation. Well, how then do we judge the legality of these kinds of tests? Remember the structure of the Human Rights Code. It's really 2 parts. The first part is that discrimination question. Does the employment standard discriminate? And the second, does that standard comply with the needs of a bona fide occupational requirement? Now, in the law, we talk about the standard of proof, or the onus of proof. And in this area of the law, we have a switching onus. It's the complainant or the employee that has the onus of proving that the test discriminates. Once they satisfy that hurdle, the onus then shifts to the employer. And then it's the employer that has the onus of proving with evidence that that test is a bona fide occupational requirement. Okay, so let's think about that first question. Do these tests discriminate? Mindful again of that list of prohibited grounds like age, physical disability, and sex. Well, what the Supreme Court of Canada and most other jurisdictions have said is that there are 2 kinds of discrimination in the employment context, direct and indirect. Direct is easy. That says women shouldn't apply for this job because we're not going to hire any. That's direct discrimination. Women need not apply. We don't really see that anymore. We used to. We don't see it anymore. What we now see is indirect discrimination, equally outlawed. Indirect discrimination is facially neutral standards which have a disproportionately negative impact on certain individuals. So think about a job requirement that says, for example, employees need to be 6'2" in order to have this job. That doesn't say anything about women not being available to be hired. If women are 6'2", they're certainly welcome to be hired, but it's going to have a disproportionate impact on women. In human rights law, that's equally discriminatory if it has that disproportionate impact, even if there's no intention at all to discriminate. So intention is taken away entirely. You don't need to have malice. You don't need to have an intention to discriminate. You just need to have the impact of discrimination. And sometimes courts will turn to what they call systemic discrimination. For example, statistical analysis of the number of women or minorities in a particular workplace to indicate that there may well be indirect discrimination at work here if the participation rate of groups in society are extremely low and underrepresented in various kinds of workforces. So how does then adverse impact discrimination work? Well, the latest Supreme Court of Canada case on this says that really any adverse impact based on a protected characteristic will result in a finding of discrimination. So really that raises the question then, will all physical standards of employment trigger that adverse impact on grounds of sex, physical disability, and age. And there's been some discussion about that in the literature. In my view, I think virtually all physical employment standards prima facie discriminate because of physiological differences in the aging human, certainly on questions of ability and physical disability, and on questions of sex as well. Doesn't matter that some women can be trained to pass a standard. If the starting point is that certain groups have physiological advantages from passing those tests, I think that's going to be sufficient to be characterized as adverse effects discrimination. Which really means that the onus is going to switch to this second question. Can employers justify these testing measures as bona fide occupational requirements? Marion says, and other jurisdictions offer similar kinds of tests, but in Canada we say an employer will have to satisfy 3 questions. Is that standard rationally connected? They virtually always pass that standard. Of course they are. There's some connection between fitness and the ability to do the job. Did they implement this test in good faith? Again, employers virtually always pass that test. Yes, they were trying to have a fit workforce. They did so in good faith. Here's where all these cases actually turn, is on step 3. Step 3 says, is that standard, is that test, and is that cut score? And it's important to remember, I think, that each of those 3 elements needs to be reasonably necessary to perform a work-related purposes. How Maorian translates that requirement for reasonably necessary is that employers are lawfully entitled to test for the minimum ability to safely and effectively perform the job. The minimal standards, not preferable, not average, but the minimal standards and cut scores to safely and effectively perform that job can be qualified as bona fide occupational requirements. I think everything in addition to that is illegal under human rights law. So if I turn now to what do employers need to think about, or the scientific community when they're designing these tests, I think it's to grapple with this notion of recognizing adverse impacts, frankly conceding that in most physical standards there's going to be some adverse impact, and really then transferring the argument or the thinking about these physical standards, not from the question, do they discriminate, but really, are they reasonably necessary? Deriving those standards, the tests, and the cut scores then from a diverse population of employees. One of the problems that many of the testing mechanisms have traditionally run into is that they're testing homogeneous or overly homogeneous groups of employees, usually men or younger men, to derive those performance standards. And what Maorian says is, if you've got a diverse workplace, you've got to derive your testing from the abilities of that diverse workplace. So that needs to be built into the composition of the test right at the original testing conception. The importance of criterion validation and really the I think movement away from what the literature calls construct validation. So criterion validation is testing to the extent possible actual job demands. So remember, what did Marion fail? She failed a construct validation test, which said she had to run this run this set number of kilometers in a particular amount of time. Well, the court said, what was the relationship between that race and the actual demands of her job? And when the employer said, well, our employees need to be fit, that was not near sufficient evidence, because the test was not specifically tailored to the job and the job demands that she was asked to do. So most industries, I think, have moved away from those kinds of generic fitness testing into designing tests that test specific qualities in the workplace, although I recognize there are challenges in doing so. Again, I mentioned this a moment ago, but then translating those standards, and Bruno will talk about the difficulties of doing this in a minute, into minimum standards? What is the cut score for your ability to carry that hose up a ladder that translates into the minimum standards to safely and effectively perform the job? And finally, I think a lot of industries tend to set these tests and then run them for many years or decades, even while the demands of the job changes. And I think you've got to test your tests. You've got to make sure that they remain current with your changing workforce, changes in technology, and as demands of the job change. Because you may find that a set of tests that are bona fide occupational requirements at the outset cease to be bona fide occupational requirements 10 years later when you're in fact over-demanding certain physical skills that the needs of the job have in fact now changed. So a test that's at one point legal may become illegal over time. What about complying with the duty to accommodate, which is the second part of that bona fide occupational requirement? So even if an individual fails then to comply with a bona fide occupational requirement, Canadian employment law has said, and human rights law, that you have a duty to accommodate that employee. And that's generated a tremendous number of cases as well. What does that mean, this duty to accommodate someone who's failed a test? And I think employers need to have a process where they consider, well, again, is that test representative of all aspects of the job? Can we think about changing aspects of the job so that certain physical demands are, if they're not required of every employee, then perhaps we don't need every aspect of a particular physical standard for employment to be passed. And to think, too, about temporary solutions. Maybe individuals need time to train. Maybe individuals need time to recover from injury. And I think just because an individual fails a test at first instance, Canadian law is going to say that's not complying with the duty to accommodate. You need to give that employee a chance, an opportunity to pass that test, perhaps on future occasions. But that doesn't mean that employers need to keep employees that are not physically fit for a job, especially, again, remember, if you've established good minimum standards for employment and an employee falls below that, either in applying for the job or in keeping that job, then an employer has to be able to say, that means that employee needs to be terminated. If there are no reasonable accommodations, if it's going to be too expensive or dangerous to keep that individual employed for the safety of themselves or the safety of their coworkers, then that is going to comply with the limits of the duty to accommodate, in my view. Well, what are the future legal issues that are likely to arise? I think there may be some around this idea of quantifying adverse impact for purposes of the discrimination analysis. So do these tests discriminate? And remember, I was arguing that essentially my conclusion, I think, is that almost all physical standards for employment will discriminate. In the US, they use what's called the 80% rule. If 80% of the 80% of the protected group, 80% fewer of those individuals. No, let me get this right. Where the pass rate of a protected group is less than 80% of the pass rate of the majority group, the U.S. court system says that discriminates. Canadian courts haven't done that yet. They haven't used mathematics to try and quantify adverse impact. Instead, they've simply just found, as a matter of physiological difference, that adverse impact exists in Maorian between the differences between men and women in their ability to run long distance. I think Canadian courts will continue to do that, but there may be issues around some attempt to try and quantify when adverse impact exists. There are passages in Maorian, that Supreme Court of Canada case, that also say maybe you need different tests for men and women, taking into account their different physiological differences. I think that doesn't make much sense, especially if you take seriously the idea that these should be minimum standards for employment. If there's a minimum standard of employment for men, it seems to me that needs to be a minimum standard of employment for everybody in order to safely and effectively do the job. So that part of Maorian, I think, is unwisely followed. And I think, remember, if we go back to the Human Rights Code's protection now of gender expression that further complicates the matter. Because what if an individual who was born male but who expresses a gender as a woman says, I want to be judged by this different female standard that has been set in this workplace? I think the better course of action is to avoid that problem entirely by having real minimum standards that apply to all. Something that also happens in a number of industries is the use of data from these physical standards from employment tests to rank candidates. And again, I know that that's a widespread practice. I think it's vulnerable, highly vulnerable to human rights challenge. Because again, remember, if you're preferring candidates that have higher scores in physical standards for employment testing, you're going to disproportionately favor individuals that have an easier time physiologically doing well on those tests, namely young men in most cases. Again, that's just a generalization, but I think it's borne out by the science. And so, again, I think it's open for individuals to challenge the use of data in that manner as being, again, indirect discrimination. That's widely outlawed and prohibited in the US, and I think if there was a challenge in Canada, you would arrive at a similar result. Why don't I leave you then with a few concluding thoughts and that ominous black space on my presentation. The idea that human rights values, I think, are best protected by diverse and safe workplaces. I think it's a mistake to put these two concepts in tension with one another. Both diverse places and, in my view, safe workplaces are protective of important human rights. Secondly, I think it's important to design, increasing diversity in workplaces, in my view, is going to create conditions that encourage innovations that also make workplaces safer for all. And I guess that's really an elaboration of that first point. I don't think increasingly diverse workplaces need to be thought of as making our workplaces less safe, but rather creating the conditions in which different abilities may actually contribute to thinking about the job demands in different ways, which may encourage actual overall enhancements in safety. Which is not to say that, again, thinking back to that danger slide, that we should render our workplaces unsafe. That doesn't make sense. So the law may set the frameworks of this analysis, but it's science and scientists that will drive the testing and the innovations that, in the words of the Supreme Court of Canada, will build conceptions of equality into the workplace. And I'll leave it there. Thanks very much.
Thank you very much, Eric. Next up to speak with you is Bruno Zumbo. Zumbo, I like Bruno Zumbo, from the University of British Columbia, who is going to be talking about methodologies and standard setting. So thank you, Bruno.
Thank you so much. And just a couple of points that I want to say transitioning. First of all, I totally disagree with Lynneth. As a professor who teaches graduate courses in statistics, I wrestle wolves on a weekly basis. Good. If something's funny, my left hand will go up. And if it's sad, my right hand will go up. And also, I think Eric brought up so many interesting elements that I want to build on that I think it's just wonderful to actually follow up at this point. So thank you, Eric, for a really terrific slide. My slides are going to have a fair number of words on them. That's as much for me as it is for you, because some of the concepts get kind of fuzzy pretty quickly. Just to get us all on the common ground, I know that we've already said this, but let me just say it so that it's at least at the table for all of us the same. What we're talking about here is tests of physical fitness for employment purposes, that is fitness for duty. And these are widely used in a variety of settings, as Lynneth said, in emergency response occupations, law enforcement, firefighting, a variety of roles in the military service. A critical step in the development and use of these tests of fitness for employment purposes, that is fitness for duty, is to establish one or more cut points dividing the test score range into two or more ordered categories, reflecting, for example, pass-fail decisions. Let me tell you what I mean by that. A fairly typical test in this field is comprised of I'll go over here. It's really comprised of a set of tasks, physical fitness sort of tasks, and we often measure the time. And so let's say we have test scores that range from 6 minutes, 40 seconds, which is like 400 seconds, to 9 minutes, 20 seconds, which is about 560 seconds. And so what we have here is a continuum, a ruler. And that's the sort of image I want you to start taking. In case you're wondering, I did not draw a distribution on this ruler. There's no sort of bell curve or anything on there, partly because I don't think that's the place to start. I think the place to start is the ruler. The critical step in the development and use of tests of physical fitness or employment, for employment purposes, or in fact for any purpose, is to establish one or more cut points dividing the test score range into two ordered categories, fail and pass. So if we, in this case, the cut score is 480 seconds, below that is a pass, above that is a fail in a physical fitness test. So it's kind of the inverse of what we typically think about as pass and fail. What Eric highlighted for us is, from a legal framework, some of the issues around setting that cut score. So over the last 3 decades, elaborated theories and methods have evolved, focus on the process of setting that cut score. This elaborated process is widely referred to as standard setting. I'm going to try and clean up some language in a few minutes. As such, the validity of the test score interpretation hinges on the standard setting, which embodies the purpose and rules according to which the test results are interpreted. Now, where do I come from? I'm actually not a physiologist, nor am I a lawyer, although I've needed both of them recently even. No, I'm not. I'm kidding. I haven't needed a physiologist. Good. That was excellent. You're tough. This is a tough crowd. They really are. Maybe it's Saturday afternoon and the super typhoon is coming. Really makes it a little hard. I actually am a statistician, a mathematician by training, with a fair amount of background in philosophy of science, and you'll see this woven through everything that I'm going to talk about. I came to the field, or I was dragged to the field early on by people like Stu Peterson and others shortly after the Mioring case in 2000, 2001 in Toronto, where we had our first national meeting around it. It was before the Australian meeting, 2000, 2001, and trying to deal with these sorts of things. And it was the first time in the history of physical employment testing in Canada that a psychometrician or statistician, a measurement specialist in my case, actually came to talk to you folks in the discipline. I don't know of any other case where an actual psychometrician or statistician is involved at this level. So Canada is, I think, a unique situation in having someone willing to come and chat and learn. Not just chat, but learn, because I think it's two-directional. And so there's a lot of very interesting things. So I'm going to be coming at it as someone who's actually worked in the field of measurement and testing. I'm a professor at the University of BC in Vancouver, and that's the program we teach in. We actually have a doctoral program and a master's program in psychometrics, measurement, testing, and all of it. And so I want to get you to think about this a bit more detailed. I have 2 points I want to make for you, and this is sort of foreshadowing my message. The first point is I want to highlight some sort of definitions, concepts, and methods. And the second is I want to bring a perspective on standard setting, a new perspective on standard setting, really reflecting what I think of as a new science of measurement. And so that's the tail end of this, if time allows for me to say a little bit about it there. So let me begin with some definitions and some key concepts and some methods. This is actually from my 2016 paper in APNM, that proceedings of the conference paper. And in here I talk about, this is sort of an editing of my table 1 in there, where I talk about 5 steps in the process. The first being this step in which we prepare a description of the standard and the performance level descriptor itself. The second is to choose appropriate method for setting the cut score. We're going to talk a little bit about norm reference, the criterion reference approaches. The third is to, for either class of method, one needs to start to think about misclassification. The fourth is you make a recommendation to policymakers. And in the fifth, you begin to document all the steps and information, steps 1 and 2, 3, et cetera, to talk about documenting the whole process. Now, why is this important? Why is this table? Actually, the table is kind of useful. It's going to help us organize some of our thinking. And I'm going to say a little bit, I'm going to focus on steps 1 and 2 in the next while. But in fact, at some point, I do want to say a little bit about steps 3 and 4. Some immediate messages come from here that I want you to leave with. A little foreshadowing here for you, a little statistical foreshadowing. First, you see in the distinction between step 1 and 2 that we need to separate the standard from the cut score. We're going to talk about that in a few minutes. In step 4, you see reference to policymakers. Because in the end, and there's a whole industry of standard setting. There are testing companies, there are researchers who do this for a living. And in case you're wondering, if you want to get into a business that's lucrative and under high demand, learn about psychometrics or measurement, but learn about standard setting. Because nearly every test used, at some point, there needs to be some kind of standard setting. How many of you have taken a course sometime in college or university? Put your hand up. Good, this is the participate. Really? You didn't put, well, what are you doing here without your hand up? Put your hand up. All of you have done it. Put your hand up. And we've all been victims to arbitrary standard setting and arbitrary cut scores, right? Sure you have, on a weekly basis, right? What's a pass for a course? Well, you'll hear, well, you have to get, if you're in Professor Adams' constitutional law class, because law school's pretty soft, right? Pretty soft. You've got to get 75%. And you challenge Professor Adams and you say, well, Professor Adams, where did you get that? And he said, his first response is, none of your damn business, I'm the professor and you're the student, right? There's nothing that says to me in my employment or labor agreement that I have to answer your question. Well, okay, we're now tolerating questions from students. It's sunny days, it's 2000 something. Oh, good, that was funny. One of you smiled, the other one broke down in tears. I don't have to answer. There's no justification. And if you press a little while, you begin to realize that it's either historic, arbitrary, pernicious, or some other thing. Why 75? Why not 74.3? Why not 60? Why not 50? Why not 95? Why not 98? Answer, because I wanted to set it at 75. I'm hoping by the end of today's talk, if you're in Professor Adams' class, you're going to approach him and say, there's actually a discipline. In regular days in school, including before college or university, we accept these standards. And we do, partly because it's I think a servant-master relationship that probably best portrays it. And that actually is the sad part. My other hand goes up. So we begin to ask these fundamental questions. Start thinking about the standard, the cut score, the process, and policy. Oh, and my point here is that policymakers, in a sense, set the standard. And they set the cut score. As a person who does research in this area, you could get employed to do exactly this. And in the end, it's the person who's using the test, or the person who is constructing the test, because those aren't always the same person, or even the same organization. They need to set the standard. They need to set. There's an absolutely lovely paper that I'm going to refer to in a few minutes by Rogers, Doherty, and Peterson about 2014 that really does a lovely job, and one of the very first ones that I've seen in the physical employment standards in the world that does a lovely job. It's an exemplar paper, in my opinion, about trying to separate these ideas and really get you to think about it, and you'll see me reference in a few moments. All right, step one, prepare a description. It's important, I actually argue it's essential to draw a distinction between the cut score and the performance standard. I'm not the only one who says this in the business. There's a small group of us that have insisting on this. When you do it for a long time, at one point in time I was an Olympic weightlifter, and when you first start it, it's slow and you separate things. And if you do things for a long time, the motion becomes, I think the term is ballistic, and like that. And so when you're doing it quickly, you don't separate things. Well, I think that's dangerous. I think it's extremely dangerous in this context. Extremely dangerous. People say, oh yeah, Bruno, of course, we don't think of the cut score and the standard as the same thing. And I'm like, yeah, but you write and talk about it. The Mioring case, my rather naive legal read, but more from a psychometric statistical read, it's conflated. The standard and the cut score, in my opinion, although they try and separate them, it's conflated. And I'll tell you in a few minutes the problem with that. The performance standard is the conceptual version of the desired level of competence. The passing score is the operational version of the desired level. It's important to fully articulate the performance standard before you set the cut score. Before I turn, before you set the cut score, the passing score. Standards should help understand proficiency and performance at a particular level and how these levels concatenate, i.e. buttress up against each other, so as to inform setting the cut score. Pass, or sometimes called the pass score, and reporting back to the test taker and the stakeholders. And it's really supposed to tell us what test takers can do and what can they possibly do better. Here's the Rogers, Doherty, and Peterson paper, 2014 paper. I think this was in, it wasn't an APNM. I can't remember the journal it was in now. But I can give you the citation to it if you wish. It's all over the literature in that proceedings. It's such a lovely piece of work. But you see here, and maybe you can't see it because it's hard to read, but you actually see in this case there are three descriptors, three categories, right? There's acceptable work capacity, and then they go about and they try and list and describe what's acceptable work capacity. They did this first, with a group of specialists perhaps. We're going to come back to that. The second is unacceptable work capacity. And the third is what's called minimal acceptable work capacity. Now, in this case, we actually haven't ordered them. This is from their table, that unacceptable. If you want to do it as a concatenation, should be at the bottom. But that's okay. It doesn't really matter, because at this point, it's just descriptors. These are descriptors. They define and give us prescription for standards. For cut scores. You see, I even fall into the language myself. All right? And that was a sad moment. It's easy to slip into it, even if you're someone like me who rants about this on a regular basis. So with the description of the conceptual version of desired standards of competence, what's really the performance standard, and at hand, the next step is to translate these descriptions to the operational version of the desired level. That is the cut score. In so doing, the act of setting the cut score is less likely to be confounded by the yet undeclared conceptual version of the desired competence, making the evidential trail one needs to set more defensible. So separating them makes the evidential trail stronger. And if we're worried about defending something not just legally, I think legally is very important, but all testing organizations have a higher moral ground than just a legal defense. If you're just covering your, I think the legal term is covering your ass. Is that the correct legal term? Thank you. CYA. If you're just in CYA mode, you are really in trouble, in my opinion. Your standards have to be larger, because the legal, as I understand it, the framework there is not meant to give you the highest possible aspiration. It's quite different. It's about protection. It's about all these other things. It's about social rights. It's about the contract we have with our government, with our society. That's a very different thing than aspiring to do good work. And I'd love to debate that if there is a debate, because I really don't see that as aspirational in a large sense, but instead setting the basis for the way we should be going, and almost a more fundamental way, a protection kind of approach. Now that we've done that, then, now we can choose an appropriate method for setting the cut score. We can choose an appropriate method. And there's really two large classes. There's actually a third one, which is a hybrid of these two things. The two large classes is the norm-referenced interpretation and setting of cut scores, or what we're going to call the criterion-referenced. The norm-referenced is you obtain a sample of test takers, or a sample of someone. They take the test, you get data, and you decide some sort of cut score based on some percentile or quartile or some statistic of the data. Very common. On its own, doing that, I think that's a very weak type of rationale for setting a cut score. Because you get into the argument of, well, is it 70th, 73rd, 75th, 90th percentile? Where do you put it? You try and look for breaks in the data and all these things, but remember, it's a sample. There's going to be breaks in the data. And so I actually think and make a strong case that you need to supplement that with external criteria. The sort of criterion approach that Eric talked about. I'm a little suspicious about criteria. I embrace them, but I don't embrace them without some caution. You know, there's a sort of a phrase in my field, you scratch a criterion and you get a norm. So, and I don't mean norm the person, you get a norm if you scratch a criterion. So be a little careful. But I think you need to have some sort of external criterion, some supplemental type of information that you add to help you decide upon all the multitude of cut points you could put on a distribution. And I think that's very, very important in that one. In the criterion referenced approach, this is where you choose a panel of what I would like to refer to as experiential or subject matter experts. I was pushed after the Canmore presentation to really unpack my notion of an experiential expert. And I try to in that paper a little bit. There's more work to be done in that area. But this notion of experiential or subject matter expert. And in some senses, I don't care which one you want to fall on, but all that those two terms are meant to say is that there is something very important that an experiential expert brings to it that a subject matter expert does not. So an experiential expert, if I am setting cut scores for firefighting, that may involve fire chiefs, it may station heads, it may involve policymakers, all of whom know about firefighting. That may be an experiential expert. By sheer coincidence, they may actually also be trained in Lynneth's lab at the University of Victoria and know about the physiology of breathing apparatus and all of these other wonderful things and weights and load and all these terrific things. But I think there's an important distinction between experiential and a subject matter expert, and I think both bring something important to this. Let me just keep an eye. There we go. Doing great. So here I put this notion there. You train these panelists. Again, this Rogers, Doherty, and Peterson in 2014 did a nice job of documenting what they did. And they used a particular kind of approach in the criterion. They call it the bookmark, where you see a bunch of performances and you literally say, and they're ordered in terms of time. And you say, oh, well, that's the spot. And you put a bookmark. And then you bring this group together again. They talk, they go apart, they change. And the whole idea here that's very important is to collect at least another 2 rounds of ratings. Because what we know from cognitive science is that these sort of broadly called hot and cold systems of cognition, you do need a moment to reevaluate. And then from there, you determine a cut score by looking at the input from experts in that manner. In the end, it's still a policy decision, isn't it? In the end, it's still a policy decision. Because you might be working for the Canadian Department of National Defence, which I think that was the example, and it was the firefighting, if I remember correctly, for DND. And what was interesting about that one is, in the end, the cut score was not set by the people in that room. It was set somewhere in the organization by specialists in that area, or specialists in that area, bringing all of this information together into a meaningful way. And so the other thing, too, that's important here is to bring in panelist feedback. It's really important to find out why and where and how and that. Now, that's just one example. There's many, many others. This field has been going on in the field of testing. There's problems going on in the field of testing about 40 years. There are books and articles and more books and more articles and more tenure and more promotion and all of these things. Okay, that was funny. That's all right. All of these things that are happening over and over again. And so there's an enormous literature just on this problem alone. Do you get a sense of how this is actually a lot more complicated than, well, we've always chosen the 75th percentile? Or it seems reasonable that the 75th percentile or whatever? This is a lot more elaborated than that. So central part of standard setting consists of a demonstration that the proposed passing score can be interpreted as representing an appropriate performance. Setting a cut score without a description of the conceptual version of the desired levels, neither of competence nor of any external, neither the desired levels of competence nor any external or internal supporting information to the test data results in a cut score that is capricious and indefensible. The traditional example is this, 70% passing grade that, and it's without any other justification or without any other supporting evidence. That's what's happening far too often. You mix into it now complications like, well, I want to set a minimum, and I'm concerned about being the next Miarin case, so I'm only going to run female police officers through and set the cut score there because I believe, I don't have documented, I don't have this or that, I believe, or I wholeheartedly and honestly believe that should be the lowest possible cut score. That, in and of itself, could get you in trouble. What you need to do, and all of you are physiologists, applied physiologists. You need to build an evidential basis, an argument, a rationale based, some of which is based on data, but not all. Then you now have all the supporting information to make the case. All right. Let's take a slight switch. So to here, I've really talked about concepts and definitions, and if you can at least follow me to this point, I win. So at this point, if you're losing awareness, you need a nap, put your head down, let me get into this a bit more stuff, because this is exciting to me, but is pushing the envelope forward a little bit, I think. So let me give you a sort of a different sort of perspective on all of this. The first, it is time, I believe, to fundamentally rethink how we approach standard setting. And here I'm using the we to be inclusive. By the we, I really mean you. The you, we, and me. But the you, and the me. But the you. You need to start fundamentally rethinking how you approach standard setting. Let me paraphrase Mike Kane in 1994, and at the time in 94, I think Mike was the chair of the Department of Kinesiology at Wisconsin-Madison. Yes, there are actually statisticians and psychometricians who work in kinesiology schools. Do not be surprised that it's Wisconsin-Madison, because if you don't know the historical connection to that and psychometrics and measurement in kinesiology, I don't know why you're here, right? SAFRIT, et cetera, they were all there. So Mike Kane, post-SAFRIT and others, was the head of the department there, and I think he nudged us along in the right direction to sort of rethink about where we're going. And Mike is a straight-out statistician and measurement person. And here's the way I want to paraphrase Mike a little bit here. We have a fairly high degree of ambiguity or arbitrariness in our choice of passing score. And we want to pretend that we have this sense of objectivity because we've got a sample and we've all decided on the 73.2 percentile or some small point. The reality is there's a lot of ambiguity and arbitrariness. In many, if not most cases, it appears that there is no specific passing score that can be considered the correct passing score. And as a result, we cannot demonstrate that we have chosen the correct passing score. There is no correct passing score in an absolute, naive objectivist sense. I need us to embrace the notion that the best that we can do in supporting the choice of a performance standard and an associated passing score is to first to show that the passing score is consistent with the proposed performance standard. That's the first thing we've got to do. Next, we can show that the standard performance represents a reasonable choice given the overall goals of the assessment program. This in itself is not easy to do. A more modest but perhaps realistic goal in most cases is to assume to assemble evidence showing that the passing score and its associated performance standard are not unreasonable. And you heard Eric a while ago to talk about invoking this notion of something that is unreasonable. I will make a case, very briefly before I run out of time, that in fact, this reflects day-to-day scientific practice of what you do as physiologists. I'm suggesting that we stop thinking of setting a cut score in absolute terms and just draw a line in the sand such that the decision and its resulting consequences are permanently decided and irreversible. I think we need to get away from that. There's no perfect cut score, and only by chance, probabilistically, stochastically, is any test score the true score of a test taker. We have this thing called standard error of measurement or variability, some of which is inherent. Therefore, there are real bounds on the reproducibility of the test score, decision, the pass-fail, and on cut scores. This is not to say either it's the Wild West and we say and do whatever the heck we want to, nor is it a statement that it's completely unsolvable. In fact, I think this is absolutely solvable, and we actually have standards by which to make these important kinds of decisions. In short, it's time to rethink the traditional absolute approach to cut scores and orient ourselves to a more realistic approach based on probability and the strength of evidential trail to make a decision. And I am going to claim that each one of you, when you're not thinking about tests, do precisely this when you are theorizing, doing experiments, drawing conclusions in your own field of physiology. I'm assuming most of the people in the room are experimental or applied physiologists. All I am saying here is, in fact, I'm going to make a bold enough claim to say the level of arbitrariness is probably exactly the same in your field of research in physiology as it is here. Labs have techniques, right? Labs have techniques. Lynneth's group has a series of things that they do when they're studying their physiology. It is quite different than a person named Gavin and a woman named Jill and my colleague named Darren. They may all look at the same thing with slightly different experimental approaches. All of you embrace that naturally. Those are our decisions experimentally that people make. Yet, you don't want to embrace that when you start looking at cut scores. You start wanting to talk about what's the cut score, the absolute, can never change. Well, nonsense. You need to put your scientist pants back on, and your scientist hat back on, and your scientist gloves back on, because you're getting back into the same scientific muck that you've always been. And how do you judge one scientific theory from another? The evidential trail, i.e. the results, the tests, the experiments. Well, that's what we do here. Stop pretending that you're doing something very different in testing than you are in your day-to-day science. And that's one of the lovely things that when Stu Peterson in particular got me into this field, is that these were a group of folks who were scientists and really weren't burdened, and this is somewhat tongue-in-cheek and sad at the same time, I'll put both hands up, they weren't burdened by statistical theory, psychometric theory, which is my nice way of saying you didn't much care about measurement. And that's okay. And the principles and theories, the 100 years of research and articles and books and professorships, and you didn't much care about that. And you went on and you built what I'm going to say a scientifically sound way of looking at testing, or at least that's what we hoped that you did, setting aside the chin-up and the push-up tests that were just predictive. You were trying to develop a scientific theory. And if you embrace your scientific work and generalize it to here, building an evidential trail, then you're going to be meeting all of the basic requirements that the legal protection gives us constitutionally and legally, and actually moves us beyond. One more couple of slides, Lynneth, a couple more slides, we're okay? One or two? Okay, one or two. Here's what I really want to talk about. Here's an example of an evidential trail, and then I'm gonna make a couple more remarks and then call it a day. when you use a judgmental panel, you need to, for it to be convincing, and it's only convincing to the extent that the experts making the judgments are competent to make the necessary judgments. Meaning you have to show that. Don't declare it. You're a scientist. Show it. Provide some argument, rationale, evidence that they are competent to make the necessary judgments. Perhaps through training, through experience, through subject matter, whatever. Second, the judgments are internally consistent across replication of the standard setting process as well. Oh, okay, that's evidence. Third, in this example, judges are not subject to any identifiable sources of bias. If this very simple type of evidential trail is followed, then the standards will not fall to challenge. And in fact, if you do things like this, you're going to get even stronger evidence. One last slide, and off we go. I'm going to make a case, and I do, and I'll gladly send you some more thinking about this if you wish. This is what I'm thinking about today, like right now. What am I thinking about? Beyond, I need lunch. Yeah, none of you laughed at that one. Okay, let's go. I'm going to hold you here for one more second because of that as punishment. So you can see from my description of standard setting that declaring someone fit for work or some such claim is based on test results is a kind of claim about a phenomenon of interest to science whose definitions rely on a normative standard. A normative standard makes claims about things, how things ought to be, how we value them, which things are good or bad, and what actions are right or wrong. We base our work on a normative science, a normative aspect. It is a normative type of claim. It's a mix of objective sort of scientific work and normative, if I wish to make that, I think, rather perhaps an artificial distinction. So we have to embrace that. Stop trying to pretend that there is some naive form of objectivity, one that I might add you don't even apply in your own research. When I was in Canmore, I heard endless comments of, oh yeah, Bruno, but this isn't really scientific. Yeah, the way you do it, it's not. But it can be scientific, and that's what I'm arguing about. And I'm furthermore going to say to you that the way you do your science and the way I do my science and my mathematics also is involved of things around values. And the problem is that we don't expose them to a challenge. And I'm going to go to my very last slide here. You can read more about this later. Whoa, well, no, we're not done. One more back. Hello. What I'm advocating is the following, that we embrace what I call a new contemporary view of objectivity. It's actually not so new or contemporary in philosophy of science. You can see evidence of it going back into the 1950s. But I think it's time to embrace it. And in fact, it's the same notion of objectivity that you use on a daily basis. And I think we need to expose in a very systematic approach, look at the hidden values, value propositions in our tests and measures. Expose them, document it, make it part of our validation evidence. If we say things like, if Eric wants to be a police officer in Edmonton, he needs to be able to put on his mucklucks and his snow boots in under 15 seconds. That is a value statement. That's not just about bona fide occupational requirements. It's in fact, when I take apart B4s, they're value statements. But that's okay, because there is a process here about checking and documenting and confronting these just like you do every day in your area of science. So my new view of science is actually an old view of science. Transfer, generalize your skills as physiologists to the field of testing, and the field will be much improved. Thank you very much.
Thanks, Lynneth. I will start where Bruno left off, and what Bruno left off with was, how do we apply good science? Now, my background is physiology. My background is not in employment standards. So when I was first asked, how does one generate an employment standard? How does one find an appropriate person to fulfill a particular job? I applied scientific skills. Now, what I'm about to go through is how we in our group applied those skills. These are not the only solutions, they're some of the solutions. One of the important things, though, is if we're going to use science and use it in an applied way, that we pay homage to science, not to the application. And if we do that, then we're going to develop a whole series of questions. Science is based on answering questions. So there's a framework for developing those questions. It's been generated, as Bruno said, back in 2000, but now, oh, I can't get it. Point at the screen. Again in 2015, and there are 20 steps in there. I'm going to focus on 5 of those steps in the course of this presentation. And from those 5 steps, I'll generate 7 groups of questions. And I'll show you how we have addressed those groups of questions in the particular example of developing an employment standard for firefighters. So the first group of questions relates to confidence. How confident can we be that a person who we accept into the job can actually do the job? How confident can we be that a person who we reject is incapable or unable to do the job? So 3 questions arise from that. Here's the first one. Do our tests measure qualities or physiological attributes that are actually relevant to the job? And I would love to work in Eric's job because I can poke so many holes in so many standards and so many tests that do not answer that question. Well, they answer the question, but the answer is no. So the second question that arises from that is, can one be certain that a person who we take into a job actually perform the job, and equally as importantly, can they perform it without injuring either themselves, their colleagues, or members of the community? And from that, it must follow that if we reject somebody, we must be confident that those people cannot do the job. They may injure themselves, the members of the community, or their colleagues. So those are our first questions. If we then think about this as in a little schematic, on this axis we've got some sort of a screening test with a score, some high value, some low value, and on the bottom axis we've got a performance we've got a performance score. So these represent data for a group of people. What happens if we put a cut score right there? So Bruno's just been talking about that. All the people now indicated in red, they did not achieve a passing score. Those in green did. Right, but how does that relate to performing the job? We have to integrate these two. So let's put a line there. And so now we've got 4 regions, quadrants. The bottom left, we could say identifies those who truly cannot do the job and were identified through the test as being unable to do the job. So our true negatives. To the right of that, these are false negatives. These are people who could have done the job. These are lost opportunities, but they failed the cut score. And perhaps because the cut score was not a good reflection of the job. If we go up to the top, we can see we have our true positives in the top right. They can do the job, they pass the test. Top left is looking at false positives. These are the people we need to be concerned about because they will go into the job, and in doing the job, they may actually injure themselves. So this group of questions I'm going to skip over, not because Bruno took 15 minutes longer than he should have, but because I always did plan to skip over this section. And it's a series of questions. In fact, I've generated 69 questions. And you might ask, well, why did you develop 69 questions? There's an answer to that I'll give you later on this evening after a beer or two. We've got questions related to right through these 20 steps that we think need to be either answered all considered in working between finding out what the job is and defending it against the person on my right. Or, not against, but with. So I won't go through these questions one at a time with you. In the interest of time, we'll just skip straight through these. But you can see there are a few on there, and I do want to just highlight one of them, and it's subject matter experts. This is information that Bruno has already covered. So let's move now to our questions related to the physiological demands of a job. And I've isolated two questions here. And the first one is, how do we identify the physically demanding aspects of a job? And as Bruno was talking about, we could do interviews, we could have focus groups, we could do surveys, we can make observations. Second question is, how do we then filter those tasks that we identify into tasks that we would say are essential for the job and are also physically demanding? So I'm jumping straight through to what we did with our firefighters. We actually developed a list of 31 tasks. The details are contained elsewhere. What I want to do is to go through how we separated those 31 tasks into a group of tasks that we could use for developing a screening test. So the first question that we asked, and these are all, this decision tree is a simple yes-no answer working all the way through. So it's our filtration process. So the first question was, is the physical effort for this task below some critical threshold? Writing with the pen, that's not physically demanding, so we can identify a number of tasks that are not physically demanding, so we would do that. And if I go backwards, what we did, we actually had two tasks. They're set aside, there's one of them, and there's the other one up there. These were what we set as calibration tasks. Before going into this activity, we knew that some tasks were incredibly easy, and we were going to survey the firefighters to get them to rate their tasks. And so we put in there two calibration tasks because we figured every individual would answer the question of difficulty related to a task in a common way. And we could, if there was bias in there, we'd be able to identify that bias by virtue of the fact that we had calibration tasks. Okay, so that was our critical value. And so if we said yes, it was below a critical value, then we asked another question. Is this a very important task? Because sometimes a task is only ever done once, but if it's not done, if it's not done correctly, bad things will happen. So importance is really important. And is it a frequently performed task? And so if we said no to that, then we would exclude that activity from that group of 31. If we said yes, then we would come across and join over on this right-hand side, and this right-hand side is coming down from here where we've said no, it's above some critical threshold, so we've come down, and now does the task involve duplication? And what I mean by that, we might have 5 tasks which are effectively the same. They're carrying stuff in the right hand. It's just different stuff. So why would we want to measure and test that multiple times? And so if it was a yes, then we would exclude it. Then if it was a no, then we'd say, well, okay, is it a 2-person task? 2-person tasks are hard to evaluate in the field because one person may do more or contribute more to the performance of the task than the other. And so we needed to be aware of that. And then if it was a 2-person task, was it skill-based? Skill tasks can take sometimes several months or years to learn, and you can't develop a test that requires learning. You have to have a test that someone can do with minimal learning. So we were going to exclude those activities. Then, and if we said no, then we'd add the task to our final list. And if we said no to it being a 2-person task, we'd then come over and say, well, is this task difficult to define? That is, does it seem to go on for hours and we can't really determine when it starts and when it ends? Is it a really unusual, strange, randomly occurring type of a task. And if it was, then we would exclude it. Okay, so from that, we ended up taking these 31 tasks down to a group of 15. Those 15 tasks were what we felt were the essential tasks of firefighting that we felt we had to study physiologically before we could understand what were the physiological demands of a firefighter. So, next question. How do we characterise or how do we measure those physically demanding jobs? How do we collect our data? We can do work observations, we can do simulations. As it was said before, with simulations, we're going to miss reality. Can we deal with that? Is it acceptable? Are there other ways that we can successfully perform a task? And do they differ between people? Is it different for a man and a woman? Is it different for an older, experienced person from a younger person? These are questions that we need to address and answer. Okay, so there's a group of 15. I'm just going to take 2 examples from this group. And as you'll see, one is the one with the greatest oxygen consumption, and it was a lower body activity. That's this one. And the other one was an upper body activity. And I'll show you what we did with those 2 tasks. And of course, we did it for the 15, but we don't need to bang on about that. Now, Lynneth, at the opening, presented the front cover of the proceedings from the conference that we ran back in 2012. That figure was on that thing. You were paying attention, Bruno, you noticed that, of course. Okay, so what did we do? We were going to collect data, and we were going to collect the usual data: oxygen consumption, minute ventilation, heart rate, and perceived exertion. You should be warned that if you do not have the capacity to measure oxygen consumption, you should under no circumstance attempt to predict it from heart rate. And over a few beers later on tonight, I'll explain why, but I don't have time now, but it's really important that we understand that limitation. So now, who do we study? Now, I go back now to what Eric was saying. In the Mioran case, the standard was not developed necessarily on a wide range of people performing the job. So we took great care to make sure that we covered the widest possible range. So, and we also took care to make sure that our distribution, our gender distribution, reflected that of the workplace. And so currently, less than 5% of the firefighters in this organisation were women. And so that's why we didn't need to have 2. We tried to get 2 in every one. One would have satisfied that criterion. But have a look at the age range that we studied. We made sure we covered the entire range, the youngest to the oldest. We deliberately made sure, I can't get it, there it is there, our mass. I haven't actually got the mass range, but we covered from 55 up to almost 110 kilograms in body mass. So we took the largest possible range. And these people were then doing this activity. Righto. So I don't need to tell you much about that. You can probably imagine how that panned out. So it was a stair climb task, and we've got 2 graphs here, and I want to explain a little bit about these box plots just briefly so everyone understands what's happening. So if you look at the coloured region first, that covers from the 25th to the 75th percentile, okay, if you like, the first quartile to the third quartile. The little line going across in the middle, that's the median score. And the little whiskers at the top and the bottom, they're the maximum and minimal values. Okay, so what we're interested in doing was calculating the... I'm going to say shit in a minute if I press the wrong button again. We were interested in how long each person spent in various intensity zones. And so I've just labelled them zones 1 to 5 and zones 1 to 5. And so in the bottom, we have oxygen consumption, and in the upper one, we have heart rate. And so we were looking to classify these activities as high intensity, low intensity, and so on. And that was the purpose of collecting these data. So this is a table from those set of results. What we can see if we look at these values here, that we've got the average heart rate and we've got the average oxygen consumption. And we now know what those average values were, but we also know how they were distributed across the task. How much time did they spend in each zone? And that's important. This next group, I want to throw it out without talking about it, but I will happily do so later. I'm one of the people who does not believe that normalising oxygen consumption is scientifically valid. I've seen over the course of the meeting a number of people talking about oxygen consumption in millilitres per kilogram per minute. For us to use that term, we have to satisfy two assumptions. That has to be physiologically appropriate, which it is not. It has to be statistically satisfied or justified, which it is not. So even though I have those numbers there, they're there just to make a point. It is more valid to express it as a power function, and I'll stop banging on about that. Right, okay, so we've measured these values. We've also studied these people performing the task, and we're now going to classify certain attributes of each of the activities. And keep in mind we're doing 15 of these, although I'm just showing you the example. And so our first group, we're going to talk about the primary fitness classification. How would you classify this activity? And in this case, we said it was about 40 to 50% strength. It was around about 25, 35% power. And strength endurance somewhere around 15 to 35%. Educated guesses, and nothing more than that. We then said, okay, what's the primary action that's involved? And I want to highlight, although you may not be able to read it if you're sitting at the back, we classified these as push, pull, carry, various parts. We then said, okay, is it a unilateral, a bilateral, what is the load, and so on and so on. Okay, so we went through all of these identification steps for each task, each of those 15 tasks. Now, we did the same for this task, which was a tool rescue. We did it for the others, and in interest of time, we'll go beyond that point. Okay, so we looked at 15. We studied 51 operational firefighters in that series. We studied men and women. Their age ranged from 23 to 57 and mass from 55 to 113 kilograms. The task durations went from really short, just over a minute, to really quite long, almost an hour. We did 8 simulations that were less than 5 minutes of those 15 tasks. 2 tasks were between 5 and 10 minutes. One simulation was 10 to 15, and another one, 5 tasks lasted 15 minutes or longer. Okay, so now we put all this information into a table. No, sorry. I haven't finished. I just jumped ahead of myself. Sorry. Greater than 50% of those tasks relied upon attributes that were not endurance-based. Now, I'm going to come back to that point in this next slide. And 30% were whole-body fitness tasks. Okay. So, coming back to that, I'm just going to... No, that's right. Okay, sorry, I got myself lost. Now we go to questions of how do we develop a test from gathering that information? It's great, but what do we do with it? Right. For each task, we now go through and say, looking at that table, let's go through another decision tree, and for each task, we ask a series of questions. The first question is the task primarily strength, or is it endurance related? If it's endurance, then we say, is it muscular or cardiovascular endurance? Now, from those tables, we've identified these attributes of the task. And if it is a cardiovascular one, was the perceived exertion on average, and that's on the 6 to 20 Borg scale, is that less than 13? Less than 13 was the standard for our calibration task. And if it's yes, then we're going to look to exclude it unless it was a really critical task, and we might think about keeping it. And if it's no, then we're going to ask the question, is there a load associated? Was there any load carried at that time? And if there's no, then we don't have anything to do. But if it was yes, then what was the load? And we classified those loads into 3 different groups. Going over now to the strength side at our first question, okay, it was a strength task. Is the load less than 10 kilograms? Now, if it's less than 10 kilograms, do we really think that's important? And it's an arbitrary decision, but that's what we thought was a reasonable threshold. And so if it was less than that, we were looking for a task that was similar, that may have had a greater load. Okay, and if so, we would exclude the lighter load one and use the heavier load. If we said no, and if we also said, so now we've got a strength task, and we've said no, and also a muscular endurance task, so we're going to now talk about these together. Is it an upper body or is it a lower body task? Upper body, what's the primary movement? And then push-pull, what's the mass, and so on. And so we've gone through every one of these 15 tasks. Now, I see some people trying to copy these down. If a quick email to me, you can have a PDF copy of the papers that have all of these explanations. As I say, these were our solutions, which we found to be well received by the group we were working with. They may not be the only solutions, they may not even be the best. They may not even be good. We think they're acceptable solutions. Okay, so having done that, this table is critical. Now, I want to preface the critical nature of this table by reminding people that in most countries around the world, the fitness test standard for firefighters is a shuttle run test, unloaded, in which they have to achieve a certain score. Okay, so what's that? That's an unloaded endurance test. Righto. Have a look at the far right of this table. Now, in this table, we've got strength and muscular endurance. Here we've got the endurance, cardiorespiratory endurance. These are upper body, lower body, and then loaded and unloaded. Have a look at, and what you'll see, each of these numbers corresponds to one of the tasks, and they were numbered 1 to 15. Have a look at how many tasks are located in the far right. Zip. It is legally indefensible for firefighters in this organisation to be tested and eliminated or recruited on the basis of a shuttle run test, because that has no relationship to the job. Okay. So, no endurance-based tasks. We had 2 tasks that were cardiorespiratory related with loads. We had 55% of the tasks were hold and carry. So what does this start to tell us? It tells us, oh shit, we've got to start to develop a test that reflects the job. So you should have hold and carry activities in the test. Yeah. 27% of those tasks were push, pull and drag. No tasks were lift and place or twist and turn. So again, indefensible to have those activities in a test. So those are our 15 tasks. Now I'm going to show you how we took out each one of those. So our first criterion was low-level demand. And from that we could eliminate tasks 3, 5, 11 and 12. Our next criterion was task replication. We had another task that was doing it. So out came 11, or he was out. Third criterion was task substitution. So out came test 6 and out came test 10. Our last one was something we discovered during the process of doing the testing. There was a policy change, a procedural change within the organisation which said task 15, using a sledge axe to enter a building, was no longer a requirement because they'd developed some other method of doing it. So it came out. And as a consequence, we ended up with these tasks. We had the carriage task of a single-sided. We had overhead pushing and pulling task. We had a cardiorespiratory drag task. And we had a critical strength task. So these were the things that we based our tests upon. And we got to that decision through applying scientific skills. Now, you don't have to be very intelligent to do this. This is not rocket science. But what surprises me is how many people screw it up over and over again due to very poor application of scientific skills. So what we can then ask is, how do laboratory tests compare with these job simulations? What is the purpose of each aptitude test? Can the same objective be achieved through another means? Are there physiological aptitude tests that are realistic simulations of the workplace? Are each of the aptitude test items absolutely necessary? Can each test item be safely performed by all who are about to do the test? How will the operational changes within the job over time, as Eric was pointing out, they have to be revisited. How will they change items in the future? So these are all things that we need to consider. I then have a series of questions that were going to be for Bruno, and he's answered most of those, and so I'm not going to go through these. I had a series of questions that were for Eric, and similarly, I hope that he's answered them, although he's fallen asleep several times in here, so he may not have. Yeah, lots of questions there.
Yeah, he actually did them.
Yeah, he did them. Because Lynneth wants us to have time to answer questions, which I think are probably more important than the presentations, I want to finish on one simple comment. Get the science right. And pay homage not to applied or sport or exercise. These are redundant terms. Pay homage to science. And if we get the science right, this man's happy and that man's happy.